Now on to MEE Live's Deep Dive. For today's top story, we're questioning the lead lawyer behind a case that's caused controversy beyond the courtroom. Last week, MEE broke the exclusive story that Hamas is mounting a legal challenge to its terrorist designation in the UK.
This application seeks to remedy that ongoing illegality and presents the Home Secretary with this historic opportunity to depart from the British state's morally and legally indefensible policy of siding with Zionism against the oppressed people of Palestine. The application argues that Hamas does not operate and never has operated outside of the territory of historical Palestine. It has no presence in the UK, and it poses no specific threat to the UK or to British nationals overseas.
A team of British lawyers from Riverway Law, One Pump Court Chambers and Golden Court Chambers submitted a 106-page application to Home Secretary Yvette Cooper on the 9th of April. It blames the government's listing of Hamas for hindering the group's ability to broker a solution to the deadly conflict between Israel and Gaza. Legal documents seen by Middle East Eye show Musa Abu Marzouk, Hamas's head of foreign relations, instructed British lawyers to appeal a 2021 decision to prescribe the Palestinian group in its entirety. Hamas's military wing, the Qassam Brigades, was prescribed by the UK more than 2 decades ago, but the more recent decision by then Home Secretary Priti Patel extended the ban to the whole organisation on the basis there was no longer a distinction between the military and political wings of the group. Patel's call met with some backlash at the time, but the ongoing bid to get Hamas delisted has been no less controversial. Joining us now to stake the case in the face of this backlash is lead lawyer on the case, Fahad Ansari. Fahad, welcome to MEE Live.
Thank you for having me.
So the full application is 106 pages. Maybe you can help us out. In a nutshell, on what legal basis do you say that it is not acceptable for Britain to prescribe Hamas?
Thank you for asking. So there's 3 main grounds for the application. The first is that Britain is in breach of its international obligations to prevent a genocide by prescribing Hamas and effectively preventing the Palestinians from defending themselves. The Palestinian resistance has manifested itself in different facets throughout the ages, and its current manifestation is Hamas. Without a shadow of a doubt, by all experts' accounts, it is the most effective form of resistance to Israeli attempts to exterminate the Palestinians. By banning that group, you are effectively stopping Palestinians from defending themselves, and you lie in breach of your obligations to prevent genocide and to end the occupation of Gaza and the West Bank. The second ground is a free speech ground, that people in the UK are being prohibited from talking about in anything other than negative terms about one of the key protagonists in this conflict. It's applied in a discriminatory manner. For example, I can stand up and talk about how I support Israeli apartheid, Israeli war crimes, and Israeli genocide, and nothing's going to happen to me. If I simply hold up a symbol that's associated with Hamas, I could get 14 years in prison. So there's definitely a clampdown on freedom of speech of people in Britain and their ability to have a nuanced and mature discussion about the conflict. And then the final ground that's been argued is that it's disproportionate in the sense that you are impeding humanitarian aid efforts, you are delaying a political settlement, and you're acting in a manner that is completely disproportionate in dealing with any alleged threat that Hamas poses to the United Kingdom or to British nationals overseas. The evidence shows that Hamas doesn't pose any specific threat to the UK national security. It does not pose any specific threat to British citizens overseas, save for those British citizens who choose to participate in an apartheid state via becoming illegal settlers or joining the IDF.
Okay, you've alluded to it quite a lot there, but I just want to make the connection really explicit. Part of your case is made on the basis of the rights of Palestinian civilians. Is it right to interpret your argument as saying that by prescribing Hamas as a terrorist organisation, the UK government is essentially aggravating the suffering of Palestinian people?
So whether the UK government likes it or not, Hamas was the last elected government of the Palestinians in what was described as free and fair elections by international observers. Since that time, Hamas is the de facto administration of the Gaza Strip, meaning that Hamas governs the hospitals, Hamas governs the schools, the street cleaners, the garbage collectors. It pays the salaries of its civil administration. And that's the excuse that the Israelis use to justify the fact that this is a Hamas-run hospital, so we can bomb it. It's a Hamas-run education system, so we can bomb it. We're already told by the BBC, the Hamas-run ministry, we can't take their statistics as anything but biased because it's run by Hamas. I mean, this is ludicrous. It is the de facto government of the area. So what that does then, in terms of individuals who want to provide humanitarian aid to anybody in the Gaza Strip, they are potentially in breach of UK counterterrorism provisions in the event that that is seen as aiding Hamas in any way. So there's a major obstacle to humanitarian aid getting in, even if the Israelis were to lift all the blockades at the moment. There's still problems with charities have told us for a long time now that they cannot get aid to where it needs to go because of these obstacles. Doctors who want to work in hospitals that are run by Hamas are at risk of falling in breach of counterterrorism legislation because they may have meetings with the hospital administrations who may be effectively members of Hamas, and then that becomes a criminal offense. And by blurring the distinction between Hamas, the political party, and the Qassam Brigades, the military wing, this is where we've got a problem now in this country. And I mean, we've had these difficulties in the past in Ireland, for example, with Sinn Féin and the IRA. But whereas the IRA was a banned organization, Sinn Féin was never banned because a distinction was recognized. A door was left open for dialogue and for negotiation, and that ultimately led to a situation where we mercifully have had no conflict in the north of Ireland for decades now. And what the application seeks to do is to try to address that problem in the terms that what Priti Patel, who was politically compromised, did when she banned the political Hamas, was to effectively go against what has been traditional British policy for decades.
So just to be really clear there, you are not calling for the government to delist the Qassam Brigades, the military wing of Hamas, as a terrorist organisation. You are focusing on the political group, Hamas.
We can't make that distinction because the government has removed the distinction. We can only challenge the removal of a ban from a group that's named in the list. What the Secretary of State, Priti Patel, did in November 2021 was to say, Qassam is no longer there, it's just Hamas in its entirety. So now on the list of banned groups, you won't find Qassam Brigade, you will just find Hamas. So we can only apply to lift the ban on Hamas. If Yvette Cooper decides that we'll bring things back to where they were in 2021, and we will just ban the Qassam Brigades, that would be a welcome move as far as our client is concerned.
Okay, thank you. So that is the case that you were making. Now, on the other side of this story, I just want to read you some reactions from the British press and public. From Spiked, an article titled, "How do the lawyers defending Hamas sleep at night?" I know members of your team have been asked this directly on air. This article, it says, the application claims that Hamas presents no threat to Britain or British citizens. Really? I guess the lawyers involved simply don't know the names Jake Marlowe or Liane, Yahel and Noya Sharabi, nor any of the 18 British nationals murdered on the 7th of October 2023. Another one which we've picked out is from The Spectator. It says Hamas is exploiting the freedoms it wants to destroy, and the author accuses you and your team directly of aiding Hamas to launder its blood-soaked record. The Home Secretary has also responded to this case, grounding down in the prescription of Hamas, and she emphasises what these other criticisms tend to centre around, which are the events of October the 7th, in which Hamas-led attacks saw 1,195 people killed, including many hundreds of civilians. What is your response to these criticisms?
I'm going to start with the last point because I think that's probably the most relevant in terms of the discussion. And I'll come back to the detractors in a moment. So yes, the 7th of October is actually mentioned within our submissions. We have provided a detailed witness statement stretching to tens of pages by Dr. Musa Abu Marzouk, who is our client who's providing us with instructions, one of the Hamas leaders. And he's given a detailed witness statement about what happened on the 7th of October from the perspective of Hamas, what was required, what the command and control structure was, what were the military orders, and what happened. And Hamas are very clear that their military orders, the command and control structure was not to target women or children, not to target the elderly. It was to go in and attack soldiers, attack military objectives, and capture soldiers. What happened subsequently after the border had gone down, and after the fence had gone down, I should say, and after the Israeli army had completely collapsed within a very short space of time, was that other factions and other civilians entered across the fence and entered historic Palestine, and then there was an element of chaos. Hamas have said in our application, in their witness statement, that as far as any crimes or alleged crimes are committed by its members, they are going to internally investigate it once this genocide comes to an end. And they are open to an investigation by the ICC or by any independent party, even if Israel is not willing to hold itself to the same standard. So they're very open about this issue. They're willing to be investigated. They're willing to carry out their own internal investigations. So in terms of how I sleep at night, I sleep quite well, actually, because probably better because I feel that this application in some way is working towards ending the mass slaughter we're seeing on our screens every day. People who are supporting Israel, I question how they can sleep, supporting a nation that has its leaders before the ICC, that is currently on trial for genocide before the ICJ, and that has been declared to be an apartheid state by the ICJ. So if you're supporting and standing with Israel despite all of those conclusions, I really struggle to see how you can sleep at night.
Thank you for responding to those statements. You are acting unpaid because it is illegal to take funds from a designated terrorist group. And I'm sure that you and your team predicted a backlash of this nature. So my question is, why did you agree to do it?
So we're lawyers. We believe in due process. There is a fundamental background factor here that there's a genocide happening. We were approached to take on this application to deprescribe Hamas. We were aware of the financial sanctions. We took advice from the Treasury. We took advice from external counsel. And we understood that there's a long and cumbersome process to obtain a license in order to take funds. Rather than go down that route, and because of the urgency of the situation, there being a genocide happening, and there being an urgent need for parties to sit down and talk with one another, we had felt a shared sense of responsibility that we needed to take this on regardless of cost. And there are 20 independent experts from around the world, including an ex-ad hoc judge of the International Court of Justice, John Dugard, Professor Avi Schlein from Oxford University, and many others from around the world, who all felt the same way, and they've all agreed to work without payment. Now, any insinuations that are being made in relation to myself and my colleagues, I would wonder if those same insinuations are going to be made about the various experts who have also supported the application, because ultimately it goes down to the fact that you have a team of people who are trying to work with their client to have due process, work within the law, and effectively work towards ending the killing. I don't think that's a controversial position to hold, and I don't think that anybody should be raising any eyebrows about that. In fact, those who are receiving payment to defend Israel before the ICJ and defend Israel before the ICC and defend Netanyahu before the ICC, questions should be raised why those people aren't asking similar questions of those lawyers.
Nevertheless, people have been raising their eyebrows, and people have been digging up, posts by you and members of your legal team. I wonder about the personal nature of the backlash. Do you not fear personal threats, or have you received any threats to your personal safety?
Sadly, in such a polarized issue, there are going to be some people who will make certain comments, either online or by email or by telephones. So to answer your question straightly, yes, we have received threats. We've received death threats. Members of our staff have been threatened. And it doesn't help when you have the Shadow Justice Secretary, Mr. Jenrick, making such comments on social media about myself, about our firm, and calling for it to be investigated. Very reckless comments. Unfortunately, the British state has a history of targeting lawyers. It happened in the north of Ireland with great tragedies with the murders of Pat Finucane and other lawyers who were acting for members of the IRA. And even in this country with Priti Patel, not so long ago, her reckless comments about activist lawyers and lefty lawyers, referring to immigration lawyers, resulted in a terrorist attack being committed in the offices of a very famous immigration practice, one which a solicitor I know personally. So Mr. Jenrick really should understand. Today, we sent a letter to the Justice Secretary, the Lord Chancellor Shabana Mahmood, asking her to intervene and to come out with a statement calling on Mr. Jenrick to cease and refrain from making such reckless comments which endanger the safety of our team and all lawyers and undermine the rule of law.
Farhad Ansari, thank you for joining us. You can read more.
Thank you very much.
You can read more and follow the story on our website, middleeasti.net. Follow the link in the description below.